I decided to make a video concerning property and property rights and to show and bring forth exactly how the state party is managing to remove our fundamental rights to own property alone and not in association with others. When you look into the International Covenant on Civil and Political Rights, you find the preamble, which explains what the covenant is about. You find it written in this way. The state parties to the present covenant, considering that in accordance with the principles proclaimed in the Charter of the United Nations, recognition of the inherent dignity of the equal and inalienable rights of all members of the human family is the foundation for freedom, justice, and peace in the world. Recognizing that these rights derive from the inherent dignity of the human person, recognizing that in accordance with the Universal Declaration of Human Rights, the ideal of free human beings enjoying civil and political freedom and freedom from fear and want can only be achieved if conditions are created whereby everyone may enjoy his civil and political rights, as well as his economic, social, and cultural rights. Again, the preamble is meant to explain what the covenant is doing, why they purported or brought forth the covenant. And here we see that it says, recognizing that in accordance with the Universal Declaration of Human Rights. So the ICCPR is an expression of the Universal Declaration of Human Rights. And now the covenant recognizes the idea of a free human being enjoying civil and political freedom and freedom from fear and want. And this human being, this man or woman, can only enjoy freedom from fear and want if conditions are created whereby they can enjoy this. So they had to create a system, they had to put up into operation a system of law that allowed a man or a woman to be free from fear and want. Well, right now, if you don't understand the expression of your fundamental rights and freedoms, the only way possible for a woman or a man to be free from fear and want is if they use their right to work and they exercise their right to work. Then they will go out, earn, pursue, and gain a living, and with that living, they will make themselves or produce an ability to be free from fear and want. They will take their resources, they will pay for their electric bill, they will pay for their food, for their gas, and for their clothing, and by doing so, they make themselves free from fear and want. But here, the International Covenant says that they recognize the idea or the existence of free human beings, and these free human beings can be free from fear and want, and this can only be achieved if the conditions are created, whereby the human being, the man or the woman, everyone, may enjoy his civil and political rights. So there is a system in operation for you to express these fundamental rights that you have and possess. Now, what I wanted to bring forward is the fact that, according to the preamble, it says recognizing that in accordance with the Universal Declaration of Human Rights. So when we look into the Universal Declaration of Human Rights, Article 17, we find the following. It says, everyone has the right to own property alone, as well as in association with others. So here we're seeing two different rights being expressed. We're seeing that the human being has the right to own property alone. So that's one side of it. Or the human being has the right to own property in association with others. So there's only two ways that you can hold your property. One is outright alone, or two is in association with others. So the UDHR, Universal Declaration of Human Rights, says everyone has the right to own property alone, as well as in association with others. The first part of this verse is an expression of your full legal capacity, of a man or woman's full legal capacity. When we looked at Thomson Newspaper Limited versus Canada, we find the following. It says, while individuals, as a rule, have full legal capacity by operation of law alone, artificial persons are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. The individual may stand upon his constitutional rights. He owes no duty to the state, since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land long before the organization of the state, long before the organization of Canada, and these rights can only be taken from him or her by due process of law and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. My right and your right to own property alone existed long before the organization of Canada. This was a natural, a fundamental right and freedom, and it found its expression in the Universal Declaration of Human Rights in Article 17. But it's not something that the Universal Declaration of Human Rights created. It was well known that a man has the right to own what he owns, and no one has the right to take it from him. Actually, back in the day, long before the state parties, the countries, became well organized and created a system of law, it was eye for an eye or tooth for a tooth, sort of. If a man came upon your property to try and steal your property or try and harm your family, back in the day, they would pull out a gun and they would tell you, get off my property or I will be shooting you. I will take your life because you are harming me and trying to steal my property. And it was a normal thing to do. It was considered normal to behave that way if someone came to try and take that which was yours. Nowadays, we have municipal police forces, provincial police forces that are there to step in and protect our rights. But that just shows us that long before the organization of the state, the man understood that he has the right to own property alone. And this expression, this right, has been now protected and guaranteed in the international covenants. When the court is talking about the individual standing under his full legal capacity, notice what they mention. He says he owes no duty to the state. He has no obligations to the state. Why? Since he receives nothing therefrom, beyond the protection of his life and property. So while I, as an individual, standing under my full legal capacity, exercising my fundamental rights and freedoms, not standing as a class of person through a statutory power, that's my full legal capacity. I owe no duty to the state, but the state still owes me a duty and obligation. And what's that duty and obligation? They have to protect my life and they have to protect my property. And the protection of my life and my property is something that existed long before the organization of the state and something that exists as the law of the land. And they're under duty and duty bound to do this on my behalf. So you don't need to have a gun in order to defend your property in 2016, but you do still have that right, as expressed in the Universal Declaration of Human Rights, to own your property alone and not in association with others. And if you choose to do so, then the state party is under obligation to protect this choice, to protect your property from being collectively placed or held in association with others. Now, there's a mechanism of law that they are using in order to remove this right that we see expressed in the Universal Declaration of Human Rights. Continuing on, when we look into the International Covenant on Civil and Political Rights, Article 22, which, as we know, is an expression of the Universal Declaration of Human Rights, which the preamble taught us, it says, everyone shall have the right to freedom of association with others. So this right had to be transferred into the state party's domestic law. Through the International Covenant on Civil and Political Rights, Article 2.2, it says, where not already provided for by existing legislative, statutory powers, enactments, or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional process and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. So this right to have the freedom of association and the right to own property alone somehow had to be transferred into domestic law, either through existing legislative powers or through the new constitutional process, the Constitution of Canada 1982. But they had this obligation. So what is transpiring here in our country is that when you buy a piece of property, land, or a home, you are actually being forced to hold it in association with your local municipality. That's exactly the operation of law that is being used against us. It comes out in the Criminal Code of Canada, what I just mentioned. When you look under the Criminal Code, you see the following expression. Property is considered a public store, and the property is being held in association or is being held collectively. So in the Criminal Code of Canada, the definition of a municipality, it says a municipality includes the corporation of a city, town, village, county, township, parish, or other territorial or local division of a province, the inhabitants of which are incorporated. So there you go. Within the Criminal Code of Canada, we see that the inhabitants are incorporated into the corporation, whatever city you're living into, or are entitled to hold property collectively for a public purpose. So they say in the Criminal Code of Canada, you can either be incorporated into the corporation or you are entitled, which means you have a right, not an obligation. You are entitled to hold property collectively for a public purpose. Now, when you read it, public stores, it says this includes any personal property that is under the care, supervision, administration, or control of a public department or of any person in the service of the public department. So, for example, you have a home, you own property, and you bring a horse and you place him on the front lawn. I know it's a funny story. Most of the time that's not going to happen, but just to see how the mechanism works. You get a horse, you put him on your front lawn. You put some hay there, you start feeding them. You're in the middle of the city. Soon enough, the bylaw officer is going to come by. He's going to say, "What are you doing? You can't have a horse in the middle of the city on your front lawn. It's not sanitary. It's going to poop. It's going to get frayed from the noise. It's going to bring increased bugs." Whatever their excuses may be, they're going to claim, we have a bylaw. We have an enactment. We have a statutory power that says you cannot do this. And what they are expressing is they are expressing the fact that your property is under the care, the supervision, and the administration and control of the public department, which is the municipal body. And anyone in service of that public department is going to come now and try to enforce the enactment or regulation against you. And this would include the police force. Why? Because the police force is hired by the local municipal government. So whatever city or town you belong to, if you have a local police force, well, the police force is hired by the municipal government, by the council, and the mayor is the head of that police force. So as these links in law form, the police are operating on behalf of the city, and they consider you a public store, and your property is under the care and supervision of them. Before you ever even purchase a piece of land, property, in a municipality, you have already been designated and placed into the corporation through a statutory power. You have been incorporated into the body corporate and are operating as one of their officers. This is the default position. You just saw it in the Criminal Code of Canada, as we talked about it, the fact that a municipality includes a corporation of a city and that the inhabitants are incorporated or are entitled to hold property collectively. Now, when you look into the statutory power itself, the enactment itself that causes us to be incorporated, we find it very clearly stated. In the Ontario Municipal Act, and I'm going to deal with Ontario in this video, but it's the same in each and every province. You have the same operations of law, you have the same enactments, the same statutory powers, and they're doing the same thing. So in the Ontario Municipal Act, a municipality means a geographical area whose inhabitants are incorporated. So here there's no wiggling around it. It's clearly stating in the municipality, the inhabitants are incorporated. Body corporate, Article 4.1. The inhabitants of every municipality are incorporated as a body corporate. So you live in the city of Toronto, guess what? You have been incorporated into their body corporate, into their corporation, into their business. You live in the city of London, Ontario, then you have been incorporated into the body corporate. No matter where you live in Ottawa, you live in Vancouver, you live in Winnipeg, you live in Saskatchewan, well, that would be the province, but everywhere that you live, you've been incorporated. City of Toronto Act. The City of Toronto is hereby continued as a body corporate that is composed of the inhabitants of its geographic area. So the default position is what? I, as a man or woman, have been classed as a class of person. I have been incorporated into the body corporate, which is my local municipality. So Toronto is the Corporation Toronto. London is the Corporation London. Winnipeg is the Corporation Winnipeg. Ottawa is the Corporation Ottawa. And you have been incorporated into that body corporate. You are an officer of the corporation. And this operation of law, when you look back into the Criminal Code of Canada, then allows them to claim that they are your supervisors, that they are your managers, that they are in control of you, that you are part of the body corporate. Now, when you buy a piece of land, you believe and are under the assumption that you become the absolute owner of this land. You choose a piece of land that you wanted, you went to see a lawyer and paid the fee to have the land registered, thinking that by doing so, you were becoming the owner of the land, the owner of the home, the property in question. Pretty soon, you will find out that there is an authority that is claiming to have power to administrate your ownership of your property. And I gave you the example before of the horse and how the bylaw officer will come to you and say you can't do this. The municipality will soon come knocking on your door claiming that you have an obligation to pay taxes and obey their bylaws. Your ownership to your property has been restricted by the powers of the municipality. Worse than that, I give you a further example. You believe you own the home. Let's say you have no mortgage on that home right now, and you're living in the home, and you fail to pay your property taxes to the municipality for a period of 3 years. Well, the municipality will come, and they will operate a bylaw, a statutory power upon you, and they will try to auction off your home to recover the taxes that you have not paid. Your home may be worth $500,000-$600,000. You may owe the city, let's say $10,000, and they will still threaten or still take action to auction off your home. That's their superior rights to your property. That's the superior ownership rights that they have over your property. So you are being forced through a statutory power to hold your property in association with the local municipal body. You see that you as an individual have been incorporated into the body corporate. Well, not only you, your property also has been incorporated into the body corporate. There is a statutory power, an enactment, a regulation that controls how the registration of the land is to take place. And as with all our rights, it is in this statutory power that we find the operation of law that limits or denies us our fundamental rights and freedoms. So when we look at the Land Titles Act in Ontario, we find the following. Application of the Act. This Act applies to such parts of Ontario as are designated by regulation. The Minister may, by regulation, designate the parts of Ontario to which this Act applies. This enactment applies against the corporate body only. The municipalities are body corporate, and it is within this context that this enactment is applicable to such parts of Ontario. Remember, a municipality means a geographic area. So you see, we're getting the description here. A geographic area, the parts of Ontario, whose inhabitants are incorporated. Body corporate. The inhabitants of every municipality are incorporated as a body corporate. We are talking about land, a geographic area, but this land is considered located inside the body corporate. Think of a car dealership that has a fence all around it. The land and the building inside the fence are part of the dealership. All of it makes up the dealership. The geographic area of Ontario is where the corporate body does business, and we are part of that body. The director of the Land Titles Act declares that this enactment is operating within that body, within that part of Ontario, in the body corporate. Now, when you look in the Land Titles Act, application by municipal council, the council of any municipality to which this act applies may, by bylaw, authorize an application to be made to the land registrar, director, to have any land that is within the municipality registered under this act. Now, the council of the municipality applies to the director of the Land Titles Act to register the land within the municipality, within the body corporate. They will divide and subdivide the parcels of land, and then they will register the municipal body as the absolute owner of the land. There will be a first charge on the registry that shows the municipality as absolute owner. A municipal council creates a bylaw authorizing the municipality to register any land with the land register. They register any land within the municipality. If you own property or are the owner or have ownership rights to property, this will come out clearly when you do business with the municipality, because they give it, your property, two distinctions in law. They say, on one hand, municipally known as lot number such, and they give it numbers. And then secondarily, they give it a residential address, whatever the address and the street number may be. So even within their own documents, you're seeing the two-sided registration that's taking place. One, the land is municipally known as lot number such, and secondarily known as whatever address it is to the lot or to the property, to the home, to the building that's there. Now, what this transpires under Article 31 of the Land Titles Act. The municipality, they register themselves as first owners to the land. They give it a lot number, they subdivide it, and then they're absolute owner to the land. They must register themselves as absolute owner each time a property, a land, is sold. If they fail to do so, then their controlling power would not be in operation. They would lose the ability to govern you. So every time a property is sold, the council of the municipality, through its bylaw, is automatically considered absolute owner. The enactment allows them to do this. That's why the first description of your property is not your civil address. It's lot number such. And then the second description to your property is the municipal address. That's showing you the qualified title. So every time someone purchases a property within the municipality, what's transpiring is that the municipality is registering themselves under that lot number. Now, secondarily, this is what transpires. For the purpose of this particular registration that is done through this article of law, the municipality is acting as an agent to the owner of the land, and it is not necessary to obtain your consent to register themselves as absolute owner of the land. Well, why would they? Without even reading what I'm about to read to you, why would they have to ask for your permission? You're incorporated into their body corporate. You do not have an executive position in this body corporate. You are simply an officer of this body corporate. The executive decides what they will do, and the officers have no say. And that's what is transpiring. But this particular statutory power, this particular enactment, actually gives them the authority to do this. Land Titles Act, no consent required. Article 31.2. For the purpose of an application under subsection 1, when you register your land after you purchase it, the municipality shall be deemed to be the agent of the owners and other persons having an interest in the land, designated in the bylaw, and it is not necessary to obtain the consent of such owners and other persons to the application. So, the municipality acts as your agent on behalf of you without your permission, without your consent, without your knowledge, and during the registration process, they title themselves as absolute owner of your land. And they say the statutory power allows me to act as an agent on behalf of the owner, and I don't need their consent. I don't need their permission. Okay, so those who are watching my video, tomorrow, wake up, go to the bank account where the local municipality does business, walk up to the teller and say, I would like to withdraw $1 million from the municipal bank account. They will say, excuse me, who are you? You don't work for the city. You don't have the permission to do that. Say to the bank teller, oh, that's okay. For the purpose of this withdrawal of money, I'm deemed to be an agent of the municipality, and they don't have to have I don't have to have their consent in order to withdraw the money. I just have to tell you that I deem myself to be their agent, and everything is fine. What would the bank teller tell you to do? Take a hike, buddy. You can't do that. But here, in their statutory power, a provision was brought forth, an operation of law was brought forth that allowed the municipality to act as your agent when you're purchasing that land, not to have to obtain your consent during the registration process. And by doing so, by having this right and taking this right, they then registered themselves as absolute owner of the land and gave you what is titled under the enactment a qualified title, a qualified ownership to the property in question. The statutory instrument declares that the municipality is deemed to be operating as your agent and therefore has the right to make declarations on your behalf. Land is purchased, a new registration takes place. For the purpose of this registration, the home you just bought, the land you just bought, the municipality is deemed to be your agent. The land is purchased, a new registration takes place. The municipality, as acting as your agent, claims absolute ownership through the municipal bylaw. An individual purchases a land or a home, and when they're going to register this land or home at the land registry, the municipality steps up and says, I'm operating as agent to the owners of this home, and I don't need their consent. And during this registration process, I'm going to do something here. And what they do is they make sure that the municipality is deemed to be the absolute owner of the land. They make sure that the municipality is considered first registered owner of that land. Again, that's why when you deal with the municipality, the property that you own, that you believe you own forthright, is described as first and foremost lot number, and then whatever series of numbers, and then municipally known as address such and such. During that registration process, the municipality made sure that they were considered the first registered owner. Now, if I woke up today and said, today I deem myself to be a pilot of a 747 airplane, go over to Air Canada and tell them, is my plane ready? I'm ready to fly. And they'll say, what do you mean? I say, what do you mean? Today I deem myself to be a pilot, and I don't need the consent of the directors of Air Canada or anybody working in that corporation. I made that declaration, and therefore I have the right. No, of course not. They would say, sir, you can't fly. You're not a pilot. You haven't been trained. What are you talking about? Well, here, because they have a statutory power that allows them to do it, they figure it's okay. No, it's not. This statutory power, this provision, this goes against my full legal capacity. Nobody has the right to represent me. Nobody has the right to stand on my behalf unless I tell them, sure, go ahead. You can't create a power that allows you to claim to be operating on my behalf and then force me to be bound to it. Now, why did they do this? Well, look at what happens when you're the first registered owner with absolute title. In Article 45 of the Land Titles Act, it says the first registration of a person as owner of the land, in this act referred to as first registered owner with absolute title. So they want to become the first registered owner of the land, and they want to be given absolute title. So they make sure that that's their position. By what? By claiming we're operating as agent for them. And what does it do for them? It vests in the person so registered an estate in fee simple in the land, together with all the rights and privileges, free from all estates and interests whatsoever including estates and interests of Her Majesty that are within the legislative jurisdiction of Ontario, but subject to the following. So what happens is that they get an absolute title. They get fee simple in the land, and they are free from all estates and interests of Her Majesty that are within the legislative jurisdiction of Ontario, free from statutory power, free from enactments and regulations, free to do with the property as they will without anybody interfering with them. That's why they want to remove you from first registered holder of the title and place you under what they designate as a qualified title. And they do it from the beginning. They go and they say, we are going to, by a bylaw, cut apart all the land in our municipality. And it's going to be known as lot number 12345. And as such, we are the first registered holder on this land. And through the statutory power, we've been granted these rights. An estate in fee simple, with absolute title, with all the rights and privileges, and free from the legislative jurisdiction of Ontario. That's our fundamental right. That's the expression of our right to own property alone, not in association with others. If you and I were operating under this provision as the first registered owner of our land, then we would be granted the rights described herein. And that would fulfill the obligation that they had in the beginning that we talked about, where everyone has the right to own property alone, as well as in association with others. And they had to transfer this right into domestic law. Not to do it through they didn't do it through the constitutional process. They did it through a legislative process. They included the provision within the enactment itself. And then they took away our ability to operate under this provision by naming themselves the first registered holder. The municipality, as first registered owner with absolute title, is operating our common law rights, our natural rights, our fundamental rights and freedoms to property. They have been given the rights to be free from all estates and interests whatsoever, including estates and interests of Her Majesty that are within the legislative jurisdiction of Ontario. The one who is the first registered owner has absolute title, and they have no obligations to submit and obey the legislative jurisdiction of Ontario, that body corporate. Now remember, a natural right is a right that is conceived of as part of natural law, and that is therefore thought to exist independently of rights created by government or society, such as the right to life, liberty, and property. The municipality is a body corporate under law, but it is a natural person under law. It can be charged with or exercise the rights that are compatible with its nature. As a natural person, the municipality claims the right in the enactment under Article 45 to exercise the natural right to property. They use Article 31 to claim that they are operating as your agent and that you have given them this right to do this operation of law. Municipality claims the right under Article 45 to be absolute owner of the land, free from taxation and free from legislative authority. The municipality claims under Article 31 that you gave them the right to operate as your agent and in doing so to take absolute ownership of the land. They register the municipality as absolute owner, first registered owner, and in this registration, in their documents, they call upon Article 45 to provide a provision and an exemption against having to ever be regulated under a statutory power under the legislative jurisdiction of Ontario. Now, all land that is registered in the Land Titles Office is subjected to provincial taxes and municipal taxes, charges, rates or assessments, and school or water rates. Now, this comes out in the Land Titles Act, where it says liability of registered land to easements and certain other rights. Article 44. All registered land unless a contrary is expressed on the registrar, is subject to such of the following liabilities, rights, and interests as for the time being may be subsisting and in reference thereto, and such liabilities, rights, and interests shall not be deemed to be encumbrances within the meaning of this Act. Now 1. Provincial taxes and municipal taxes, charges, rates or assessments, school or water taxes. So all registered land are subject to these charges unless a contrary is expressed on the register. So if something can be expressed on the registration of your property, of your land, when you're registering it, then you will not be subjected to provincial taxes, municipal taxes, charges, and so forth. Now, all registered land is subject to taxation and charges unless the contrary is expressed during the registration. All registered land is subject to these charges unless a contrary intention is expressed, unless an operation of law providing you otherwise is expressed. So if you would go there and say, well, I have absolute title under Article 45, then your land is not subjected to it. But you can't do that. Why? Because you do not have absolute title. You're not the first registered owner of the land. The municipality is. The municipality, as the first registered owners, have this obligation. However, when they register, they invoke their contrary intention found in Article 45 of the Land Titles Act, claiming that they are free from legislative authority. The municipality, the corporation, registered as first owners. They invoke Article 45. Remember, it says all registered land, unless a contrary is expressed on the register, is subject to taxes. They invoke their Article 45 and they remove their obligations to taxation to legislative authority. They operate your fundamental right to own property alone in absolute title to be free from charges. How? Again, by operating as your agent during the registration, naming themselves as first registered holder, and invoking their rights under Article 45. The municipality has taken absolute ownership over the land and property, and when you register with the Land Titles Office, you are given a qualified title. This is the term they use in law. A qualified title is a simple way of saying you are given ownership rights as long as you qualify for them. You are subjected to provincial taxes and municipal taxes, charges, rates or assessments, and school or water rates based upon the fact that you are operating a qualified title of ownership and not absolute ownership. When the municipality operates as absolute owner and first registered owner, they produce and attach an annexed document stating that the land in question has conditions and restrictions upon it. They produce these restrictions upon the land usage through their bylaws and statutory powers. They take away your rights by operating Article 45, and then they turn around and they subject you under your qualified title to provincial taxes, municipal taxes, school and water rates, and the like. If you pay them, then you keep your qualified title. If you don't pay them, after 3 years, they will remove your qualified title by coming in, removing your home, auctioning it off. Because why? Because you do not have absolute ownership. You are not the first registered holder of that title. Again, when the municipality operates as absolute owner, the first registered owner, they produce and attach an annexed document stating what you can and cannot do with your property. And that comes out in the Land Titles Act, Article 119. Upon the application of the owner of the land that is being registered or of the registered owner of the land register may register as annexed to the land a condition or restriction that the land or the specified part thereof is not to be built upon, or is not to be used in a particular manner, or any other condition or restriction running with or capable of being legally annexed to the land. That's how they get you. When the land register is taking place, they operate as your agent, invoke Article 45, free themselves under absolute title return to you a qualified title and then annex their restrictions upon the land and then enforce them through their bylaws and their bylaw officers. Municipality has absolute ownership of the land. They're exercising freedom from legislative authority. We are given qualified ownership, and we are subjected to the administration of their powers. Now, this happens unless the contrary is indicated in the registry title. We have been given a qualified title of ownership. You qualify as long as you pay them for the liabilities, such as taxation, and you qualify as long as you obey their bylaws. Land Titles Act, Application for Absolute Title, 46.2. The registered owner of land with a qualified title may apply to the land registrar to be registered as owner of the land with an absolute title. So they made the provision in the statutory power itself, once you woke up and understood what was transpiring, in order for you to change the fact that you were given a qualified title and take back absolute title, thereby operating under Article 5 with absolute title, fee simple on the land, free from all estates and interests of Her Majesty that are within the legislative jurisdiction of Ontario. The enactment makes provision for an individual who understands about their full legal capacity to do something about the limitation that is transpiring against their natural right to property. You can apply to the registrar to change your designation before them. You can take absolute ownership of the property, become the first registered owner, and then Section 45 will apply on your behalf. As such, you would be holding and operating upon your property as absolute owner in fee simple, free from legislative authority of Ontario, which is an expression of your fundamental rights to own property alone and not in association with others. The way they set it up in the statutory power, it's ridiculous. The amount of forms and the amount of things that you must fill out and must do in order to change from qualified title to absolute title is not proper. There's another operation that can be used that is a lot easier. The enactment says that if you have a problem with the director of the enactment itself, that you can apply to divisional court in order to have your case heard. While a divisional court is considered the superior court of the province, and we know the superior court has inherent jurisdiction. And if you understood how to operate and stand in court, then you could go in there and prove to the ruling Chief Justice that this statutory power, the provisions in it, have limited and abridged your constitutional rights, have limited and abridged your fundamental rights and freedoms as enumerated in the international covenants. DeVito versus Canada taught us that Canada's international obligations and relevant principles of international law are also instructive in defining the right. So international law is instructive in defining the right. And the content of Canada's international human rights obligation is, in my view, an important indicia of the meaning of the full benefit of the Charter's protection. I believe that the Charter should generally be presumed to provide protection at least as great as that afforded by similar provisions in international human rights documents, which Canada has ratified. According to international law, it is recognized that everyone has the right to own property alone or in association with others, and this right had to be transferred into domestic law. We see that the state party here in Canada is trying to say that we as individuals are incorporated into the corporation of our local municipality and that we are holding property collectively. We see that they term our property as public stores and that our property is under the care and supervision and control of the public department. We understand that through the Ontario Municipal Act, the statutory powers, all the inhabitants of the geographical area have been incorporated as a body corporate and are operating as an officer of this body corporate. The Land Titles Act, it applies to this body corporate in Ontario all across the province. What transpires? We go to buy a piece of property, a land, or whether a home is on that land. we buy the property. The municipal council operates as our agent for the purpose of the registration of the property. They register themselves as first title holder, first registered holder, and they take absolute title of the land, and they become the ones who operate our natural rights, our fundamental rights, to have the land in fee simple, free from the legislative jurisdiction of Ontario. This is against our charter rights. This statutory power is against international law, and therefore, according to the Constitution Act of Canada, is of no force or effect against us. When the land title registration takes place, the municipality, as first registered holder, annexes a bunch of conditions or restrictions that are attached to the land, telling you what you can and cannot do with the land, and are willing to enforce these conditions through their bylaw officers. Through the registration of the land, since you cannot express a contrary intention on your behalf because the municipality has stolen your rights under Article 45, your qualified title to the land is now subjected to provincial taxes, municipal taxes, charges, rates or assessments, and school or other water rates, because in the statutory power, all registered land, unless the contrary is expressed on the register, is subject to the following liabilities. And since the municipality took first registered position, absolute title, you cannot call on Article 45 under your qualified title to invoke your right to be free from this. It's up to you on an individual level to understand what's transpiring against you personally, against your full legal capacity, your recognized full legal capacity here in Canada, and to challenge the state. Because look what R versus Haynes said. Prior to the Charter's advent, the individual really had no special means of protecting against incursions upon his or her basic fundamental rights by executive or other legislative arm of the state. There were no means at the disposal of individuals to muster court challenges aimed at invalidating legislative, executive, or administrative acts. Respect for the rule of law meant this. It hinged the existence of public order, and it mandated compliance with directives and ordinances, even if they infringed upon individual fundamental rights and freedoms. A primary purpose of the Charter, however, was to change this relationship of the individual with the state and its laws by endowing individuals with an effective means of challenging acts of the state in courts on the ground of violation of their constitutionally protected rights and freedoms. Before the Constitution of 1982, if you would have learned what you learned today in this video, the end thereof would have been, well, too bad for you, because public order is more important than your individual fundamental rights and freedoms, and you are expected to submit your rights and freedoms to public order. So even though we use the provisions in the enactments to give ourselves a first registered title, and we took away absolute title from you and fee simple from you and subjected you to charges against your land, too bad. You have nothing to say. But the Charter changed this relationship between me and the state party by giving me the power, the effective means to challenge the act of the states, to challenge the statutory power, to challenge the regulation in the court on the ground, very simple ground, of a violation of our constitutionally protected rights and freedoms. We have the power as individuals now, when we understand what is transpiring, to walk into a superior court of record or the federal court under the inherent jurisdiction of that court and say that enactment, that provision within that enactment removed, limited, and abridged my full legal capacity. And I don't want it applicable upon me. And I don't want the state party to try and operate that law upon me. It's breaching my constitutionally protected rights. And as DeVito said, it's breaching international law, which defines my right. But all this hinges on the individual understanding international law, the obligation in domestic law, and then where in domestic law the action or operation of law took place to remove the fundamental right and freedom. Once they learn all that, then they have to learn how to use the court system and access the inherent jurisdiction of the court for the administration of justice. The process is possible. It just takes a lot of work. Many people were wondering, where are my rights to my property? I want to own my property alone. How did the government do this? I don't understand. Well, now you do. And your remedy is available for you, but it doesn't cost you 2 cents. And I'm not talking about money here. I'm not talking about dollar bills. It costs you effort and time to learn and study and understand what the state party has done to you personally by infringing upon your fundamental rights and freedoms through their statutory powers, and then to challenge that against them and say, you are breaching your obligation towards me as one individual.